Okay, Chapter 8, Teacher Freedoms, Substantive and Procedural Considerations. So there are two types of due process, both which apply to teachers. The first one is substantive, means that the state must have a valid objective when it intends to deprive a teacher of life, liberty, or property, and the means used must be reasonably calculated to achieve its objective. And then procedural means that the state may not deprive any person of life, liberty, or property without due process of law. A teacher must be given proper notice that he or she is to be deprived of his or her personal rights. So the 14th Amendment to the Constitution guarantees due process of law as a fundamental right for all citizens. This amendment states in part that no state shall deprive any person of life, liberty, or property without due process of law. So what that all means is that the government can't take away a person's life, freedom, or belongings unless they follow their legal procedures. And this means that people have the right to a fair trial and legal protections before the government can punish them or take away their rights. Okay, freedom of expression. By virtue of the First Amendment to the Constitution, teachers are afforded rights to freedom of expression. Within limits, they enjoy the same rights and privileges regarding speech and expression as other citizens. Free speech by teachers, however, is limited to the requirement that such speech does not create material disruption to the educational interest of the school district. And this just means that teachers are allowed to express their opinions, but their speech cannot interfere with the school's ability to run smoothly or harm its focus on educating students. Speech outside the school environment. Teachers are afforded First Amendment rights outside the school environment. They speak on issues that interest themselves and the community as well, even though their speech may not be deemed acceptable by school district officials. This, of course, has not always been the case. In the past, there was a commonly held belief that public employees, including teachers, had only a limited right to freedom of expression. Freedom of speech outside the school environment is well established. However, when exercising such speech, teachers should preface their comments by indicating that they speak as a private citizen rather than an employee of the board. One case that actually was mentioned in the text was the Pickering case. Marvin Pickering, a teacher in Will County, Illinois, he was fired for writing a letter to a local newspaper criticizing the school board's spending priorities. So he argued that this violated his First Amendment right to free speech. The case went to the U.S. Supreme Court, which ruled in Pickering's favor. The court decided that public employees, like teachers, have the right to speak out on matters of public concern without fear of losing their job, as long as their statements aren't knowingly false or harmful to their workplace. This decision set an important precedent for protecting free speech rights for government employees. Academic freedom. Public school teachers are afforded judicially recognized academic interest in their classroom based on the teacher's right to teach and the student's right to learn. Public school teachers are not provided the same broad latitude extended to professors in higher education. So kind of what this means is public school teachers, they have the same rights when it comes to what they teach because they and their students have the right to education. However, they don't have as much freedom as college professors when deciding on what to teach. Academic freedom is a limited concept as applied to public schools. It supports the belief that classrooms should be a marketplace of ideas and that teachers should be provided a level of freedom of inquiry, research, and discussion of various topics, ideas, and issues. Since public school teachers teach children of tender years who are impressionable, their freedom of expression in the classroom is limited by factors such as grade level, age, experience, and readiness of students to handle the content under discussion. And then in the text, there was a case, Fowler, she was a tenured teacher, and she was dismissed after showing the R-rated film, Pink Floyd, The Wall, to her high school students on a non-instructional day. She was unfamiliar with the movie's content, and she relied on the students' assurance that it contained only one bad spot. She rented the film without previewing it and instructed that a student to cover any inappropriate scenes using a file folder. Following her termination for conduct unbecoming a teacher, Fowler sued, alleging her First Amendment rights were violated. The U.S. Court of Appeals upheld her dismissal, deciding that showing the R-rated movie without reviewing it first and relying on the student's opinion was not appropriate behavior for a teacher. Freedom of association. The First Amendment guarantees citizens the right to peacefully assemble. Freedom of association is included within this right of assembly since teachers, as citizens, are entitled to the same rights and privileges provided by other citizens. Freedom of association grants people the right to associate with other persons of their choice without threat or punishment. Although teachers enjoy these rights, they should exercise them in light of the nature and importance of their position as a public employee. So overall, people have the right to choose who they spend time with or join groups with without being punished for it, but teachers have this right too. But because they are public employees and serve as role models, they should be mindful of how their choices might affect their job and reputation. Membership in subversive organization. The Supreme Court has held that mere membership in subversive organizations is not sufficient within itself for dismissal. This just means that being part of a controversial group isn't enough of a reason by itself to fire someone. There needs to be more evidence or justification for dismissal. So the teacher must have demonstrated that he or she actually participated in an unlawful activity or intended to achieve an unlawful objective before punishment may be met.
Continuing on, as far as teacher rights go, got into the ideas here of politics and political rights. So this really varies depending on the state's interest tests, state laws, and how they prohibit public employees from participating in all activities. It has been deemed unconstitutional. So the ways that you exercise politics within the classroom is very important to consider as a teacher. It's also very important to teach to your staff as an administrator. In regards to politics, the one that probably would be most important to have knowledge of is whether or not a teacher has a right to hold office. Typically, this is not going to be allowed. In the text, it's stated due to the fact that teachers might use the office or position for personal gain. And in doing so as a teacher, that would, of course, be frowned upon. State laws can vary regarding to the extent to which you may legally participate in personal or political activities in public office. But generally speaking, any public official, which may include a teacher, is prohibited from using their position for any gain. It did mention if a position is assumed, typically the Board of Education will ask the teacher to take a leave of absence while they perform that role. I think I have this on the next slide, actually. Yep. So they may be required to take a leave of absence. But what's important to know is that legally, a teacher cannot be dismissed because they become a candidate for a public office. So you're not allowed to legally terminate their contract. So it has to be a step, they have to step down willingly if they are going to assume that role. At this time, court rulings have varied. It really depends on the state. Some teachers around the state are gaining greater political freedom so long as there's no neglect of duty or political forum in the classroom. So it is turning, the tides are turning more in favor of the teacher to be involved in politics if they so please, and still remain in the field of education. Participating in political campaigns. So the right to campaign is afforded to teachers and other employees, of course. However, it's important they understand that their professional role transcends their roles as citizens, which to me is a funny way to say, no, you can't actually participate in political campaigns because you're a teacher, but you can, but you can't. So they're saying your role as a teacher has to transcend your role as a citizen. That means you can't use school materials, spaces, or time to promote political parties. Um, Depending on how that looks, I know in Milford, there was a subpoena for one of our school board members and one of our teachers a couple years ago when they were actively voicing against a bill in Nebraska State Legislature. Fortunately, they did not use any of the school devices to promote this political campaign, and nothing came of it. But I do know of individuals who have been subpoenaed on this before. So, popular topic, something you definitely want to be cautious of, and something you want to be aware of as an administrator. You want to have teachers who are knowledgeable on this. If they are interested in politics or politically campaigning, what's your district's policies, and how are you going to uphold that as a professional? Moving
Um,
on.
I'm just going to say something. I actually get really nervous about that because, in Bennington, they're trying to pass the bond to get another high school.
Right.
My husband wanted to put the vote yes for BPS for the bond um in our yard. And even that made me nervous. It's in our yard, it's in our yard, but still
Yeah.
even that, even though I'm promoting something for my school, makes me nervous.
Yeah, same, similar. I mean, I'm in Milford now, but I'm still around York, and York just passed a bond for their elementary school to expand. And yeah, I know their administrators were posting stuff online and putting that in their yards. So yeah, I'm not sure. I mean, of course, the school bond, if you could technically, where you draw the line, like as a teacher or a citizen, but I understand the concern there.
I
Yeah,
mean, yeah, because it's going to impact my kids. So obviously, I want to put in as a citizen. So
right.
still scary.
Yeah. Um, So dressing and grooming. So like ironically, like we talked about with chapter 4, I feel like there's no clear stance on this matter either when it comes to dressing for teachers, similar as it was kind of with students. There's actually probably more clarity with students, I felt like. Um, Teachers have the same argument as their students, which is that they have the right of freedom of expression. So they believe that they too should be able to express themselves freely. Um, and teachers do have some protection. This was more of a major issue. I don't think this is on the next slide. Yeah, it was more of a major issue in the 60s and 70s, and that's probably because you were seeing a transition from individuals going from more professional attire to more relaxed attire. Um, and so they created this idea that evidence must meet the standard of reasonableness, as in that the teacher's dress, was in prohibiting them from being able to complete their job effectively. Restricting dress based on health, safety, material, uh, substantial disruption, or community values has been supported by the courts, but it varies based on the community. There was an interesting case about a guy named Rich Brimley. He was an English teacher, I believe, in the 70s, and he had to wear a tie when he taught his English classes, but he could take it off when he taught his film classes. And he said, "No, I don't want to wear a tie ever." And he wouldn't wear his tie, and so that got brought all the way to the Supreme Court. They did side in favor of him, saying that it was not a disruption to the learning environment. He was still to a reasonable degree of professionalism, yada yada. Kind of interesting. I feel like this comes down to your teacher contract that you're going to create as a district and what they're signing, and then upholding that if that becomes an issue. But yeah, like previous school district, I feel like that was more of a concern. We had staff dressing, not in obscure ways, but just like less professional, and so something maybe your district or community would care about. I think that's a big community thing. Okay, Good one here. Right to privacy. Does it exist? Haha. Is it commonly held that teachers enjoy a measure of privacy in their personal lives? These rights should be respected to the extent that they do not violate the integrity of the community or render the teacher ineffective in performing professional duties. School boards can dismiss teachers on issues of lifestyle choice. And that's what I read in this chapter, which I found interesting and is a conversation I have with my wife frequently. Just like it's a crazy profession because it is 24/7. Like we get summers off, but really we're never out of the spotlight. Like you always have to be a teacher. And I thought that was funny how they said you can be political, but your role of being a teacher has to be above citizens. So like, no, we're always a teacher, kind of. It's just the way it is. Um, it cannot adversely oppose the integrity of the district or be detrimental to community relationships. And I think the wording on that is important because you have to understand what your community values. So in regards to the way that you uphold yourself, how are you going to maintain that image? And in regards to privacy, um, and also, like you mentioned, you have to be aware of your impact as a potential role model. So what you're doing in private, although you may think is private, could eventually be found or seen. So how does that show kids as a role model? Um, there's an interesting part about this in the chapter about unwed pregnant teachers. Courts tend to vary in rulings regarding unwed pregnant teachers. During the 60s and 70s, courts were inclined to rule against single teachers who were dismissed by school boards when they reported their pregnancy. Um, because of that, they were dismissed from the profession, which is really, really bizarre to think about now. During the 70s, mid 70s, early 80s, with increased attention focused on individual rights of teachers, courts became less inclined to rule against unwed pregnant teachers without carefully weighing all aspects of the case. In doing so, the courts considered the teacher's overall performance record, the impact of the teacher's actions on students, and more importantly, to the extent to which the teacher's actions adversely affect his or her effectiveness as a teacher. I feel like I wrote this down in here, but I may not have. Yes. An example case from Iowa. Richard Erb was his name. Essentially, a longtime teacher, I believe he was somewhere in the fine arts, um, found out that he was having an affair, became public. Um, his wife forgave him, his children forgave him, said that he announced it, like his school community forgave him for his actions. When this was found out, um, they allowed him to retain and stay in the profession, but Iowa, as a state, removed or revoked his license. So he appealed that, took it to the Supreme Court, which eventually went in favor of Richard Erb, saying that his actions were not, as they say, adversely or opposing the integrity of the district, and it means to be detrimental to the community's relations. So I don't know, crazy to think about that. Would never want to be an administrator in that scenario. It would sound terrible. And that's kind of this last slide talking about considering community standards and the degree to which teachers conduct themselves. I will say, I will note, at the start of January, or maybe it was the end of December, I watched a Hot Comms podcast or episode, which is like with, I think it was KBS Law was on it. I can't remember, but the idea of teacher privacy got brought up. That being OnlyFans, of course, with teachers, and that idea being brought up more and more in how they're ruling. And interesting enough, they said there were some cases siding in favor of the teacher in other states, as long as it didn't create disruption in the school building. I can't imagine, like, how do you legally create that distinction? I don't know. That would be, I still like that might be the more common issue instead of unwed wives as teachers. That's probably what we're transitioning to is like teachers creating something like that and how you're going to deal with that. Okay. Religious freedom. So teachers do possess the right, religious rights. However, they must remain neutral in all matters regarding religion in public schools. They're free to fully exercise their religious rights outside normal school activities. Protection also includes religious observances, practices, and beliefs. So districts do have to accommodate to these religious practices if you need days off for them, etc., unless the school has undue hardships. That was the terming they used. However, interestingly enough, if this does come about and the teacher is not able to be to get days off for religious observances or whatever, they, as a teacher, have the burden of proof to demonstrate that the district denied certain freedoms. So it is that teacher's job to prove that case. Finally, on to FMLA, created in 1993, as it says here, designed to allow eligible employees up to a total of 12 work weeks of unpaid leave during any 12-month period for one or more of the following reasons. These three: birth and care of a newborn child, placement with the employee of a son or daughter for adoption, and or caring for an immediate family member with a serious health condition. Um, Talked about the creation of FMLA. It was interesting that this was not a thing until 1993. Oh, and of course, fourth on medical leave when the employee is unable to work because of serious health conditions. So, last note or caveat, employers with 50 or more employees are covered by this act. I was just thinking about what about if there's a really small school that has less than 50 employees, they still honor that or not. You do have to work for 12 months to be eligible for this, or for at least 1,250 hours. And that's what I just said right there. All right. That's it for chapter 8,
Hey.
Teach Your Freedoms. Yeah.